Okay, good afternoon, everybody. My name is Toby Monette. I teach in Commerce and in Business Administration here at Vanier College. So let's begin this session by presenting Vanier's land acknowledgement. We acknowledge that the place in which we work and study is situated within the unceded lands of the Kanien'kehá:ka peoples, part of the Haudenosaunee Confederacy. There's also a strong historic presence of Anishinaabe peoples in what is now known as the Greater Montreal area. Tiohtià:ke, or Montreal, has also long been and continues to be a gathering place for many First Peoples from all directions. We honor and thank the traditional custodians of this land and strive to work for the success of future generations. Furthermore, we cannot have an acknowledgement without a commitment to action. At Vanier College, we are striving to remain engaged in the process of conciliation by incorporating all principles of the Indigenous Educational Protocol in our current strategic plan. We will continue to work for the success of future generations of students from all backgrounds. So just a note for the Zoom viewers, if you wish to ask any questions during or after the presentation, if there's time to respond to them, please type them into the Q&A box, which you may access by clicking on the Q&A icon at the bottom of the Zoom window. Verbal access and the chat function have been disabled for audience members during this webinar. Now I'll introduce our guests. Dr. Natasha Bakht is a full professor and the Shirley Greenberg Chair for Women and the Legal Profession. She teaches at the Faculty of Law Common Law section at the University of Ottawa. Professor Bakht's research interests are generally in the area of law, culture, and minority rights, and specifically in the intersecting area of religious freedom and women's equality. She has written extensively in the area of religious arbitration. Her research on the niqab analyzes the unwarranted popular panic concerning Muslim women who cover their faces and explore systemic barriers to inclusion perpetuated by Canada's legal and political system. Her book, In Your Face, Law, Justice, and Niqab-Wearing Women in Canada, was listed in the Hill Times 100 Best Books of 2020. She has been cited by the Supreme Court of Canada in R versus Nova Scotia, or R versus NS, CNS, and I think Nova Scotia, a case involving a niqab-wearing sexual assault complainant. So I'll stop talking. I'll let Natasha come up. Thank you so much.
Hey everyone, I'm just going to start with a video.
We were good friends.
But we had actually only known each other for about 3 years when he was born. Yeah, I don't think either of us ever contemplated that we would become family.
We'd had some funny moments where she'd been out with him, you know, at an appointment or something, and people would say, "So who is he to you?" And it was strange to just say, "Oh, he's my friend's kid," you know, because he was so much more than that. We love Ilan for who he is and want to give him the very best life possible. And, you know, we're going to do that. We're going to do that no matter what.
Can you hear me now? Okay, great. My name is Natasha, and I am one of the women who you just saw in the video, different hair, but same person. My friend and colleague, Linda Collins, and I have been friends now for over a decade, and we are not spouses, and we're also not a same-sex couple. We don't cohabit together, although we do live in vertically adjacent apartments in the same condominium building. And we have been parenting our son Ilan for a number of years now. We treat our 2 units as the upstairs and downstairs of a shared family home in some ways. In other ways, we co-parent Ilan like any other parents who don't live together. Our unique living situation, I guess, defies easy categorization. Some might say it's sui generis or unique, but we consider ourselves a family that shares unconditional love, trust, and consistent care as our foundation. So I made the decision in 2009 to become a single mother by choice using anonymous donor sperm. Over the course of my pregnancy, Linda offered to become my birth coach. And Linda was present at Ilan's birth and was the first person other than the surgeon to see him. I imagine that Linda would be a significant person in Ilan's life, but we didn't intend at that time for her to become his parent. About 6 months after Ilan's birth, it became clear that he was not meeting typical developmental milestones. After several tests, Ilan was diagnosed with periventricular leukomalacia, which eventually resulted in the more specific diagnoses of complex cerebral palsy, among other conditions. Ilan is nonverbal, though his comprehension is very good. He communicates by using hand-operated switch devices and by answering yes with his smile. He requires assistance with all activities of daily living, including mobility, dressing, toileting, and eating. He's fed through a gastric tube, and he uses a variety of adaptive equipment, including a wheelchair, a wheeled walker, a standing frame, and various types of specialized seating. He's a bright, joyful, beautiful boy who adores music, school, and the outdoors. Ilan needs 24-hour care, and he will likely continue to need that care for the rest of his life. Very quickly following Ilan's birth, Linda's role as an important auntie in his life turned to that of a daily caregiver alongside me, her role increasing over time to the point where she became really a second mother to him. Linda is intimately involved in all areas of Ilan's daily life. When he was just a year old, Linda sold her 3-bedroom house to move into my condo building so that she could help to raise Ilan much more conveniently on a daily basis. We share all child rearing, including day-to-day responsibilities relating to Ilan, such as feeding him, dressing him, bathing him, attending to his schoolwork and social life, attending to his medical care and his therapies, and all the regular day-to-day and major aspects of child rearing. We, along with Ilan, eat meals together, shop together, visit families and friends together. We nurse Ilan's hurts together, and we plan for his future together. We share in Ilan's financial support, and we coordinate our teaching schedules so that one of us is always available to care for Ilan should he be ill or have a doctor's appointment. Most importantly, Linda and Ilan share a deep, loving bond that is characteristic of a parental relationship. Though he can't express his feelings verbally, Ilan's responses and interactions demonstrate that he experiences Linda as one of his parents. And I also treat Linda as a co-parent, involving her in all aspects of decision-making regarding Ilan's medical care, nutrition, schooling, recreation, and therapies. Eventually, we sought to have our de facto parenting arrangement recognized in law. And this was important to us for a number of reasons. For me, it was about peace of mind. Given Ilan's specialized needs for care and support, which are only going to increase as he grows older, knowing that Ilan has another legal parent to rely on was reassuring to me.
Having Linda as a second parent would ensure that Ilan would be eligible for her medical insurance benefits, the disabled dependence provisions of her pension, and that he could inherit on intestacy, and that he would have another person legally required to meet his needs physically, emotionally, spiritually, and financially. For Linda, it was primarily about being able to say to doctors, teachers, I mean, really anybody who would listen, this is my son. But a formal recognition of her parentage would also ensure that Linda could consent to medical treatment, register Ilan in school, claim him as a dependent for tax purposes, and make any decisions regarding his education and moral upbringing. Without the formal recognition of her parentage, if anyone were to question Linda's legal relationship to Ilan, she would really have none other than that of a babysitter. So we also felt it was important to honor the relationship that had grown so organically between Linda and Ilan, and to simultaneously challenge the historic hegemony of marriage and one-size-fits-all models of parenting. So in April 2016, we filed an application with the Superior Court of Justice, Family Court Division in Ontario, seeking a declaration of parentage for Linda. We filed affidavits outlining our position that Ilan's best interests would be served with legal recognition of Linda's role in his life. Our application was filed as a basket motion or an unopposed motion, and thus we were not required to, but we prepared to submit a factum or a legal brief. We would have argued that the court should use its inherent parens patriae jurisdiction. That's an inherent jurisdiction that the court has to protect vulnerable members of the family like children. And we asked them to use that declaration to grant a declaration of parentage for Linda for 3 reasons. He said it would A, be in the best interests for Ilan to do so, B, that there was a legislative gap in the Children's Law Reform Act, and 3, or C, non-conjugality is not a legal impediment to the proposed declaration. So I'm going to focus my comments today on our first and final arguments. In our application and draft factum, we argued that it was in Ilan's best interest to have Linda's role as his parent legally recognized through a declaration of parentage. Because his needs for care and support are profound, and because as he gets older, meeting his needs physically, emotionally, and financially will become even more challenging, having 2 legal parents would be a significant benefit to him. Now, you might ask, why did we go the declaration of parentage route and not have Linda adopt Ilan? And you'll have noticed that in the video, we use the language of adoption. In fact, we couldn't have Linda adopt Ilan because the Child and Family Services Act, which is the adoption legislation in Ontario, precluded Linda from adopting Ilan because she's not a relative by blood or marriage. And I would have had to give up my parental rights to Ilan in order for Linda to adopt him, which obviously was not something that we wanted. We were also unable to make use of the simplified step-parent adoption route because we were not in a conjugal relationship. Now, the fact that marital status was the only hurdle preventing us from accessing the step-parent adoption provisions in the Child and Family Services Act is discriminatory, and it's almost certainly unconstitutional. We opted not to pursue this legal route. And we did that because the future care of a child with disabilities like Ilan is exorbitantly expensive. And we felt it would be financially irresponsible to spend that kind of money on a constitutional challenge to the legislation. A declaration of parentage, which is another legal route that we could have used, and the Court of Appeal of Ontario said that a declaration of parentage provides the practical and symbolic recognition of the parent-child relationship. So it confers the same rights and obligations as those of biological or adoptive parents. So in other words, it was another legal route to really getting exactly what we wanted. In a case called AA and BB, like in a case called AA and BB, it was significant that I, as Elan's biological parent, supported this application for the declaration of parentage. My support of the application showed that a loving and capable parent and the person who knows Elan best also trusted the applicant, Linda, to care for her child like a parent. The ultimate question, though, ought to be whether a declaration of parentage is in the child's best interests. So this might include an inquiry into whether the parent seeking a declaration has a parental relationship with the child, whether there is love and affection between the child and the applicant parent, the length of time that the parent-like relationship has existed, the ability and willingness of the proposed parent to provide for the child, and the child's preferences, if that's ascertainable, and the relationship between the parent and the applicant parent. Now, this would obviously be a context-dependent, fact-specific inquiry that puts the child's interests first. Importantly, a best interests inquiry must not import questionable biases, such as a desire to raise 4 children to be raised in an environment that most closely resembles the traditional heteronormative family. Because the court's parens patriae jurisdiction is fundamentally about protecting the interests of vulnerable children, it allows courts to draft individual remedies for unique situations. So in our case, to establish that it was in Elan's best interest to have Linda declared a parent, we gathered affidavits or sworn statements from friends, family members, and Elan's professional caregivers and teachers to testify to the vital parental role that Linda plays in Elan's life, and that his family is healthy, happy, and functioning well. Parents of children with complex disabilities face a significant risk of caregiver burnout and physical injury throughout the lifetime of their children. By granting the declaration of parentage, we argued that the court would be serving Elan's best interests both directly and indirectly by providing an additional level of security and assurance to his biological parent. Parents of children with complex disabilities are often particularly in need of support because of the dramatic financial and emotional impact of raising children and supporting these children in a society that is not responsive to their various needs. In such a context, state support is clearly critical to ensure that both the caregiver and the child are given the assistance that they need to thrive. However, recognizing more parents can also introduce the potential for creating more financial support, more hands-on care, and more comfort, which will tend to be in a child's best interest. Elan really revels in playing and spending time with his family. He recognizes Linda as his parent. He knows he can depend on her for care. Though the legal declaration would in some ways have no practical difference to our daily lived reality from Elan's perspective, we took the position that it was in his best interest to have Linda's role as his parent legally recognized. And we said it was important for law to catch up with life. Our draft factum also argued that nothing in the Children's Law Reform Act or the jurisprudence prevents the court from issuing a declaration of parentage in a non-conjugal context. So the Children's Law Reform Act permits courts to recognize non-biological or social parents where the parent-child relationship has been established on a balance of probabilities. For all practical purposes, we are in an analogous situation to ex-spouses who are functioning effectively in co-parenting their child. The fact that a conjugal union never existed between us is immaterial, we said, to Ilan's best interests. A person's ability to love and offer emotional support to a child depends on his or her personality traits, such as the ability to have empathy or sympathy, understanding, and kindness. And it doesn't really have a logical connection to that individual's marital or relationship status. Indeed, any analysis that focuses on the conjugal or non-conjugal nature of the relationship between the parents and really fails to focus on each parent's relationship with the child and their ability to co-parent simply misses the mark. In terms of parenting ability, there's really no logical reason to privilege sexual connections over others. In fact, to do so would be to fail to offer much needed support to more vulnerable families, particularly those raising children with disabilities. An insistence on conjugality also disregards and discourages the myriad ways in which people exchange love and care. If law is to remain neutral among the various visions of the good life, it must be open to alternative family formations while remaining ever vigilant of a child's best interests. The Law Commission of Canada presciently argued in its report, Beyond Conjugality, that individuals must be accorded the maximum freedom to determine the relationships that matter to them. The state ought to support any and all relationships that have the capacity to further relevant social goals and to remain neutral with respect to an individual's choice of a particular form or status. Ultimately, the court was convinced that it was in Ilan's best interest to have Linda as a second parent, and we received an order on November 7th, 2016, formally declaring Linda to be a parent of Ilan. Now, we were, of course, thrilled by our legal victory, but just weeks later, on December 5th, 2016, the All Families Are Equal Act, which made amendments to Ontario's Children's Law Reform Act, among other statutes, received royal assent. The Attorney General of Ontario explained that the goal of the new legislation was to treat all children equally and to end the uncertainty that parents face when their children are conceived using assisted reproductive technologies. The new act sought to address several issues, including the rules regarding the use and reimbursement of surrogates, preconception parentage agreements, and really it was the first overhaul of antiquated parentage laws in the province since 1978. The intention of the legislation was certainly progressive in that it attempts to dismantle the historically presumed connection between biology and parentage. And it recognizes to some extent that families may take different forms. The new legislation is particularly significant in providing clarity and certainty to LGBTQ parents who conceive through assisted reproduction, eliminating the need for the non-biological parent to have to go to court to have his or her parental rights recognized in law. The new amendments settle in advance the legal relationship of donors of genetic material with respect to children born through assisted reproduction. And it permits multiple parents, up to 4 people, whether they are in a same-sex relationship or they are non-conjugal parents, to be recognized without a court order. Importantly, under the All Families Are Equal Act, putative parents must form the intention to parent before the child's conception. And that intention must be formalized in a preconception parentage agreement. This requirement certainly makes sense when one considers LGBTQ plus parents, generally because these are parents who plan the birth of their children in advance and they need certainty in this planning process. But the intention to parent preconception is not the only way to ensure that children's interests are put first. Loving families can and are created after a child's birth. Indeed, this is what step parents do, those who stand in the place of a parent as it is understood in the context of child support. They do that too. So the All Families Are Equal Act precludes a declaration of parentage where the intention to parent arises after a child's birth, even where such a declaration may be in the children's best interests. The act appears to fetter courts' ability to utilize its inherent parents' patriae jurisdiction or its protective power over children by precluding the issuance of a declaration of parentage. So if our case had been heard under the new amendments, it may have prevented our family from being legally recognized. The legislative debates, or the Hansard for the All Families Are Equal Act, reveals that some members of provincial parliament were concerned about these restrictions placed on declarations of parentage. For example, the Honorable Sherry DeNovo disagreed with the condition requiring the intention to parent to be formalized prior to conception. The fact that these concerns were contemplated by the legislature means that people who are excluded from the act by virtue of forming the intent to parent after the child's birth may not be able to use the court's parents' patriae jurisdiction. Now, a 2017 case called ML and JC suggests that courts may, in fact, be willing to exercise their parents' patriae jurisdiction where an individual was not recognized under the act, but was acting as a parent, and the other parent or parents consented to him or her being recognized as a parent. And I'd say that's a good thing. A more flexible approach to declarations of parentage is prudent because family forms are not set in stone. They are constantly evolving. In British Columbia, for example, Section 31 of the Family Law Act permits courts to issue declarations of parentage if there is a dispute or any uncertainty as to whether a person is or is not a parent. This section of BC's Family Law Act leaves open the possibility that courts might grant declarations of parentage in situations outside of those explicitly contemplated under the Act. Loving parental relationships can be created in a myriad of ways, and courts must have the ability to examine on a case-by-case basis new family formations in keeping with changing social realities. Such a residual provision in Ontario would have, I think, avoided excluding some families from an act that claims to be about the equality of all families. Now, perhaps the statutory limit in Ontario was implemented to appease opponents concerned with floodgates or to protect the autonomy of intended parents from future interference by drawing a bright line. But the case law certainly does not suggest a stampede of adults seeking to parent children where they are not obliged to do so. In fact, the reverse is true. Many family law cases are about people trying to avoid their parental duties, whether in the context of child support or missed access visits with their children. And even if people were clamoring to parent children who already have parents, I'm not convinced this is necessarily a problem. I think an appropriate feminist application of the best interests of the child principle ought to be able to guide the best interests of the child principle, guide judicial decision-making in interpreting the best interests of the child principle. I am, of course, mindful that courts have tended to favor heteronormative two-parent households, but certainly children can thrive in single-parent families, and where disputes arise, I would say that the custodial parent's views should be given substantial weight. Philosopher S. Matthew Lau argues that every able person in appropriate circumstances has a duty to promote a child's being loved, even when the biological parents are available. Some parents, whether they are single or partnered, may successfully discharge their duty to love their children using their own resources, whatever that entails in terms of funds, emotional and physical reserves, and time. But many people may find this difficult without assistance, owing to the demands of employment, caregiving of other family members, the special needs of some children and parents, mental health challenges, or other factors. That other persons also have duties toward children can alleviate the burdens on the primary caregiver and promote all children's well-being. Historically and contemporaneously, examples abound of care for children by people in addition to biological parents. Indeed, the patriarchal nuclear family has never been the norm in many sociocultural communities. In African American and Indigenous communities, a network of people, in addition to biological mothers, have often cared for and raised children. Grandmothers, aunts, other relatives, and non-relatives who are treated like family have all been part of networks of care. Community-based childcare has historically been critical for Black women who have had to leave the home in order to work and provide for their families. Where childcare is unaffordable or non-existent, these other parents have played essential roles in childrearing. Professor Sarah Morales notes that historically in Coast Salish communities, grandparents or great aunts and uncles raised children, especially the firstborn. With Hulkimunum family units, even today, all the offspring of one's aunts and uncles are considered to be your brothers and sisters. In South Asian communities, multi-generational families are commonplace and numerous. I often get asked how I felt when Linda asked me if she could become one of Ilan's legal parents. The truth is that I barely needed to think about it before answering in the affirmative. And my ease with sharing parenting in this way is likely because I was raised in an immigrant Indian and Pakistani community in Toronto, in which the majority of my local extended family were not biologically related to me. These aunties and uncles loom large in my memory as they functioned as additional parental figures. Linda, in turn, was raised in a blended family with 4 parents, 2 biological parents and 2 step-parents, who arrived at different points in her childhood and who brought with them step-siblings and a half-sibling. We both learned through experience that it's love that makes a family. The communal caring for children by numerous people in addition to biological mothers, which is also known as alloparenting, dates as far back as the hunter-gatherer period. Anthropologist Sarah Blaffer Hardy has argued that human evolutionary history is characterized by cooperative offspring care. She notes that Homo sapiens could never have evolved if human mothers had been required to raise children on their own. Because infants are so dependent at birth and remain so for years, mothers had to rely on social supports extending beyond their own kin to raise their young. Today, people are seeking multiple paths to family formation, including intentional non-conjugal parenting units. Many people are connecting on co-parenting websites such as Modamily or Family by Design, which offer opportunities to find co-parents, as well as resources for those who want to share responsibilities for raising a child together without necessarily being in a romantic relationship. Jessica Feinberg makes an argument for why friends ought to be able to adopt together in the United States, arguing that single individuals who are eligible to adopt on their own, but who choose not to because of the difficulties inherent in raising a child alone, may adopt if allowed to do so jointly with a close friend. A New York Circuit Court allowed an uncontested second parent adoption by two friends who were co-parenting a child adopted from Ethiopia. Justice Mella interpreted Section 110 of the Domestic Relations Law, which had been amended to permit adoption by any two unmarried adult intimate partners, to include non-conjugal partners. So Justice Mella held that the legislature intended for the phrase adult intimate partners to encompass more than just common law partners or sexual partners. Indeed, she said the experience of jointly and intentionally partnering a child is itself of the most intimate nature. In terms of stability, many people enter conjugal relationships in search of the one person with whom they expect to spend the rest of their lives. However, these relationships arguably involve a greater chance of dissolution than close friendships, which studies show are important, stable, intimate, and committed. Many women report feeling emotionally closer to their female friends than to their husbands, and research shows that women usually make a deep commitment and devote a great deal of time and intensity to their friends. Now, this is not to suggest that non-conjugal co-parenting units are superior to their more traditional counterparts. In our view, our case stands for the proposition that there is no limit to the configuration of relationships that can support the healthy raising of children. Our co-parenting arrangement came about organically, and we felt that it worked for each of us, and especially for Ilan. In our view, the most effective parenting requires being flexible in form so as to be able to respond to all parties' needs and interests as they evolve. Many people play crucial roles in a child's life, and parents and children require ongoing support from multiple sources. This is especially the case for parents raising children with complex disabilities. That non-conjugal co-parenting has been a necessary part of our history and continues to exist in more contemporary cultural practices, suggests that the state, social agencies, and other institutions should support conditions for all kinds of relationships that further children's right to be loved without reference to conjugality. Most families want what is best for their children. They want to be able to create a home or homes that are safe, loving, and happy environments. As society acknowledges the ever-expanding cadre of family compositions, we're trying to make the argument that law should not lag behind. Thanks very much, everyone. I'm very happy to answer any questions you might have.
So I can pass this around if anybody has a question, so that way we don't have to have too much movement. raise your hand and I'll come to you. I think that these students have another class, right? You don't just have a bunch of good students.
Yes, I was told that they do have a class.
Correct. So thank you for having us quietly as you can, everybody. And for those of you who are able to stay, are there any questions?
Hi. I was just making sure that hopefully you didn't already answer this in the beginning, but I was just wanting to know that you mentioned you had to prepare a legal brief, even though it's not very necessary. How long did it take for you to prepare it?
Yeah, that's a great question. It took a little bit of time because, as I said, we had to gather sworn statements. So we had to ask for affidavits from Ilan's teachers, his caregivers, his principal. He happens to have a lawyer. So we gathered all of those statements and then we really had to make an argument. I mean, fortunately, we're both lawyers, so we do this kind of work. We had a lawyer who we'd hired, but what we did was we drafted the argument, which was, I think it was about 15 pages long. So it took the time that it takes to put together a 15-page document, probably a couple of weeks. And then our lawyer reviewed it and submitted it. So in fact, the legal process was very efficient. Sometimes when you read media about our story, it sounds like we had a long, arduous uphill battle, but actually we submitted our application. I believe it was, it took about 6 weeks, 7 weeks max for us to get a successful declaration of parentage. And we often say that, in many ways, the law was prepared for our unique family situation because of the really important work that scholars and activists in the LGBTQ community, the legal work they had already done, the groundwork that had been set by family law scholars and people advocating for single mothers. So in many ways, the law responded exactly how we wanted it to respond.
Maybe you could answer the part that the student didn't quite, but I think you might have been implying this about why you put in that factum, even though it wasn't required.
We essentially, you want to make the job of the judge as easy as possible. And so you want to sort of, in your argument, what you're sort of trying to do is make the argument that you hope the judge will come up with, so that they really just have to read your legal brief and say, this is our decision. And the decision is based on, these sort of arguments. So we didn't have to prepare the factum, but by doing so, we just created a situation where it was hard not to grant us the declaration that we wanted.
I think that might have been helpful for some of the students thinking of going to law school at some point, just to understand some of the legal niceties there. Are there any other questions? I'm sorry.
Hello, how do you think the dynamic would change if your friend had a partner before or even after the co-parenting happened?
Well, it turns out she does have a partner now. Yeah. She's had a partner for about 3 or 4 years now. So we've been really lucky to have another person join our family. And, we've always wanted for each other to have a romantic relationship. And our view was always, we'll see how that happens. We'll cross that bridge when we come to it. But our hope was always for that to happen. And I guess what we had talked about was whoever the romantic partner is getting not just, their romantic partner, but also that partner's kid and that kid's other mother. And so it is a lot, you're taking on a lot, certainly as a family, but we've been really fortunate. Linda's partner, she's a lovely woman and has had a real connection with Ilan from the very beginning. And so, we kind of couldn't have asked for a better person who's really intimately involved now in Ilan's upbringing. She very much is the favorite parent of Ilan's. I think the other two mothers are a little boring compared to this younger, hipper woman. So, I don't even like my relationship with Linda. And this is not the case for everyone, but we didn't sit down in advance and create an agreement about how it is we would like to raise Ilan, but we also found that we sort of had the same values. And with Linda's partner, it's really been the same thing. It's been a very organic evolving of the relationship on all levels. And we've been very fortunate that we have the same values. We really value kindness and having fun, and really allowing everyone to do the things that they want to do in that relationship and supporting everyone, which is not to say that we don't have disagreements, but we also recognize that where we might be short with each other or where we might have a disagreement, that we sort of allow that to happen, but then always come back and have a conversation about it. And so that's a very important value that we've been very fortunate to kind of share.
That was a really great question. Does anybody else have one? Back to you.
I was just actually curious on, with Ilan's particular case, how he learns and how he performs at school, like just with learning in general, or even test taking, if there is even any of that.
Yeah, that's a good question. So kids with disabilities who cannot, what's the right word? When he was very young, they sort of did some testing to determine whether or not he could engage with the provincial curriculum, even if that was in an alternative way. And so they found that, he was able to engage with the curriculum. And for those kids who might not be able to engage with the curriculum, there's sort of another stream where, they're doing fun things with the children, but there might not be the same goals around education. So Ilan has an alternative curriculum, but he does sort of the usual things in school. He does math and spelling and social sciences. His cognition is quite good, and we think it's about age level. But he is nonverbal. So the big thing for him is trying to access, what he's thinking, what's going on in there. And so it's a learning process. And he's currently so he used to have a switch that was activated at his head. And he would sit in his wheelchair and he would hit the switch. And so we learned when he was, about 4 years old, that he knew the letters of the alphabet because the teacher would say, what letter makes the sound B? Is it C? And he would wait. And is it a B? And then he would hit his switch, which had a recording device that says, that's the one. And so he would hit his switch and say, that's the one. So we knew that it was a slow process, but we knew that he knew all the sounds of the alphabet. Since he's gotten older, we have found that he actually prefers to use hand switches. So now he has a yes switch and a no switch. But sometimes his spasticity acts up and it's hard for him you can see that he's working quite hard in order to do small movements. So we also always say to him, your smile can be a yes. So he's using that kind of technology. And we've also recently discovered that his vision is much better than we thought. So he's now using eye gaze technology. So there's a monitor, a sort of computer screen, and it can follow the gaze of his eye. And so what he has to learn to do is look and dwell, so hold his vision at a particular spot. And then the computer can say the word, or can look at an image and say the word. So it's like learning a language, and he's very much in the early stages of that. It will probably take several years, but it's a nice way for him to learn to communicate. And, as his mother's we often know what he wants because we know him intimately, but that doesn't help him out in the real world. He does need to learn to communicate effectively with people who don't know him the way his mothers do. So that's an ongoing learning process. And, sometimes he's frustrated by it. I mean, we're very lucky. He's a very happy, easygoing child. But, he's entering his teen years. He's 12 years old now. And we expect that, he probably will get frustrated as he's unable to communicate as effectively as he might want. So there are multiple ways in which we sort of try to access education for him, but that's some of the ways we do it.
So I just want to thank the student for bringing that question up, since the whole purpose of your talk, the main message was best interest of the child. And I think it's so important that we talk about your child in that, and that we talk about the child. So thank you for raising that. I appreciate it. I'm sure you do as well, Natasha.
Yeah.
I have no idea what time it is. Do we have to? Do you?
If there are no students, I mean, we prefer to give you guys the mic, but if there's nobody right now, maybe my question will spark another. Thank you so much, Natasha, for that wonderful presentation. I guess I had two questions. The first was, given the sort of what might be described as unconventional sort of, organization of your family household, I wonder if you could speak a little bit about the reactions in your surroundings, perhaps from family and friends on for both co-parents. Yeah, sure, and involvement as well. Like, do you get other help and support? And then the second question was just about, because as you mentioned, Ilan requires constant care, and you talked about some of the physical and emotional, but you're on top of being this super mom, you're also a very accomplished legal scholar, professor. You've written a bunch of books. So I wonder, how do you just, maybe this is like my mom side asking you this question, how do you manage like how, yeah, like how do you generate, I mean, even just, I'm thinking like the emotional energy and the mental energy to do this other very serious work when you might be feeling physically depleted, or, and I'm sure there are emotional highs and lows too, in accompanying someone with some of these difficulties.
Okay, so reactions to our family. I have to say we've been really fortunate in that the reactions that we've gotten for the most part have been extremely positive. In the early days when Linda would accompany me to medical appointments, people just assumed we were a same-sex couple. And fortunately, the reaction was very normalized, very easy. Occasionally a doctor might say, so who is everybody? Just want to know. Before the declaration of parentage, we'd say, well, Linda's my best friend, and this is their relationship, and it was slightly awkward. But we've been very, very fortunate that our family and our friends have really been nothing but accepting and warm and positive. And like I said, that's an important value for us. So we really don't surround ourselves with people who would have any other reaction. My family knew Linda as a friend for a short period of time before I made the decision to have Ilan. I have to say my mom wasn't thrilled with me wanting to have a child being unmarried. In fact, she said to me, unmarried girls don't get pregnant and have children. And I said, I was a law professor at the time. And I thought, really, I'm an unmarried girl? But that so quickly changed. As soon as I got pregnant, she just very quickly switched to, okay, I'm here to support you. I think they felt relieved that there was another person there who was so committed to both me and Ilan. Our story got a lot of media coverage, and most of it was incredibly positive. I did get some good advice early on. Somebody said, don't read the comments. on the internet about your story. And for the most part, I didn't read the comments, but at one point when we were writing an article about our story, I did read some of the comments, and there were some nasty comments, racist and homophobic comments. And, of course that affects you. And of course you feel vulnerable and upset by that. But I think for the most part, we were really, really fortunate to just actually be able to, for the most part, that's not really been a part of our reality. And that's been really important. And the second part of your question was about balance. Yeah, I mean, it is a tough thing. I always say that sometimes I wonder if we're doing a disservice to young women in particular, because in environments like this, you're very much in an environment where you believe, and you should believe, that you are equal, and that there is really no distinction between you and your colleague who may be male. And then you decide, you become sort of a child rearing, you become childbearing age, and you decide to have a child, and suddenly it's very different, and suddenly you don't have the same supports that, really, like, having a child radically changes your life. And I'm not talking about a child with disabilities. I'm just saying having a child radically changes your life. It changes every single decision that you will make. It changes whether you can decide to go out for a coffee in the morning, whether you can go see a movie, where you're going to live. It radically changes. And that's not a bad thing, but it really is constraining in many ways. And I'm just not sure that we prepare our women students for that. So that can be tough. That can be very difficult. I'm really lucky in that I don't experience my parenting as burdensome. We want to give Ilan the best life possible. And so we have a great time. We travel around the world, and that's becoming more challenging because he's getting physically bigger, and people who run airlines just don't expect people with disabilities to travel, so there's no space for someone other than a teeny tiny baby to have a diaper change on an airplane. And so, you learn to become a real advocate, and you learn to say, this is what we need, and you're required to provide this for us. And if you don't, we'll file a human rights complaint. We've done a lot of those. But I would say balance is, to me, parenting and law. And, before I went to law, I was a professional dancer and choreographer, and I still have that part of my life. It's still very much around for me, but all of those things really feed me and give me a break from the other. So, I always really encourage students to do the work. So that has been very important to me. And being a professor is a wonderful job, and I highly, highly recommend it. You have a lot of autonomy in terms of when you do your work, and, the teaching commitments are there. But to me, the teaching is something that really inspires me, because, young people are bringing in fresh ideas that I hadn't thought of. That's really wonderful, and it changes from year to year. So, often the balance is about scheduling. And really just making sure that we have a shared Google Calendar now, and the three parents are figuring out how best to organize our lives. If the scheduling works out, I often say that the balance is there. And there are definitely times where one is more frustrated, or we don't feel like we're getting enough help. The pandemic was an incredibly challenging time for, I think, a lot of parents. So, it's not always an easy journey, but we sort of keep puttering away at it, keep sort of trying, at least in moments in one's day, to find the balance, even if you don't find it all the time.
Do we have time for? Okay, so I see my colleague over here, Alan, and you'll all have to excuse my funny walking here. Okay, Alan.
If I understand correctly, all of the sort of legal wrangling that you did was at the provincial level. And then you also mentioned that BC had also done some. So what, in terms of the sort of the country as a whole, because you say you didn't want to launch a constitutional challenge because of the financial commitments to that. What does your case and other cases that have kind of come forth provincially, what might that mean for the rest of the country in terms of this kind of recognition?
Yeah, it's a great question. I mean, family law is provincial for the most part. The Divorce Act is one piece of federal legislation. But the truth is that parentage laws for the most part are provincial. And so really at this point, I tried to kind of look into this before arriving, thinking that somebody might ask a question like this. But I think at this point, it's Ontario and British Columbia that have a more expansive understanding of parentage. So you can have multiple parents, you can have non-conjugal parents. I don't think the other provinces have begun to implement that yet, but I think they're thinking about it. So I think even in Quebec for some time now, there has been some discussion about the need to reform family law. And I think cases like ours, especially when they get the media attention and really for the most part, the receipt of our case, the reception to our case rather, was so positive. I think the Canadian public was really ready for, they had an appetite for these kinds of stories. So I think, it does put pressure on governments to really, the truth is these kinds of families exist in all places in Canada. And so in many ways, it does make a difference to people to have law really catch up with life, as I said. So I think that those changes are coming. They have to be coming.
Thank you. Do we have any other student questions? Okay, I'm getting my exercise today.
This could be a little silly, but if you do celebrate, how would you celebrate like holidays? Like, do you all go to one grandma's house? Do you like have separate holidays or all together?
Yeah, no, not a silly question at all. Linda and I often travel together. So before her partner came into our lives, the three of us would go on vacation together. Both sets of our parents, as it turns out, live in Toronto. So we were often taking trips to Toronto and spending a few days with my family and then spending a few days with her family. Now that she is partnered, we all four of us will go on trips together. So, we're all here in Montreal for the first time traveling after 2 years. So that's kind of fun. We've been to, Linda's partner is from France. So we've been to Bordeaux and Geneva. And so we can travel together as a foursome. And sometimes Linda just wants to travel with Justine, which is fair enough. And so the two of them will go off on their trips and they make sure that grandparents or aunts and uncles are around to support me while they're away. So we sort of do a whole bunch of different configurations, but we're very much, negotiating with each other pretty constantly about, can I do this? Can I go away? Is this all right? Should we have Elan come? So we're sort of open to all possibilities, but we really do see each other as a family. And often that means, if one of us is being invited to dinner, it's the whole family that's coming. So, yeah.
Do I have any other questions from students?
Oh, religious
okay.
holidays. Yes, good point. We also tend to celebrate pretty much everything. We have a, celebration is a good thing. I come from a mixed religious upbringing. So my mother is Hindu and my father is Muslim. And I've always been raised in both religious and multiple cultural traditions. And Linda comes from a Christian / secular tradition in her family. I think she's probably more, she'd describe herself as sort of more Christian spiritual now. So we celebrate a variety of different festivals and religious holidays. And we do it in our own sort of unique way. Schools will often write to say, you know, if you celebrate a particular religious holiday, let us know. So we'll send in books about Diwali or Ramadan in order to make sure that the children in Ilan's class know, you know, what he celebrates. So we're pretty open-minded, and we're sort of willing to take any celebration, any excuse for a celebration, really.
I again want to recognize our students for thinking about how
Yeah.
your life works and how your home and your household works. And I'm really impressed with you for trying to think that through. The theme of this International Women's Week is what is family? And you're
Yeah.
really thinking about that. So good on you. Final questions from anybody? All right.
I'm really curious to know, like, if you add children into the picture, like if your friend wants to have more children, or if you want to have more children, like how would that work?
I don't want to have more children. But it's a good question. And that is something that we're sort of working out because Linda's partner is a little bit younger than us. And I think she does want to have more children. And so, you know, we are having conversations about that. And if I sound hesitant, it's only because I'm going to be turning 50 in the summer. And, you know, the thought of having more sleep deprivation and diapers and, you know, just all of the things that come with a newborn is a little bit daunting. But I also don't ever want to crush someone's dreams, you know, if that's what they want and I want her and my family, then that's something that we have to negotiate. We absolutely have to talk about that. And, you know, maybe a series of conversations, or it may be, you know, you absolutely must do what you need, but what's this going to mean? What's the impact on me? What's the impact on Ilan? How do we make this so that it's something that, you know, where we can all flourish? So, you know, this is, I guess, the thing is that families change all the time. And it could be because someone wants to have another child, or it could be because someone suddenly develops an illness, you know, and so you have to be able to, you have to be prepared to negotiate change all the time. And, you know, I really don't like change for the most part. I like things to be stable and exactly the same, but that's just not realistic, you know? So I think it's important to be open to having those conversations. And you know, we try to do that. It's a good question. Thanks.
Okay, so I think, any last takers? Okay, so I guess I have the great pleasure of thanking you for this amazing talk, and you made me think so much. And for a person who says that you don't really like change, it seems like there's change all the time around you, but you're always sort of negotiating and talking. And to me, that's such an important message, that for a family, whatever the configuration, it's about the talking and the negotiating. That's a very good reminder for me in my life right now. So thank you. I'm so glad this was today. And so I want to thank you for being here and for speaking. And I really want to thank Layla for asking you to come and for hosting us all. And especially want to thank the students, because, well, you're all awesome and we love having you. So, you know, we love being with you. That's why we're here. Layla, is there anything else that you, no, I did it. I did a good job of it. Okay. You said.
Just a reminder to the folks who are following us on Zoom and to the folks in the room, if you can stay at 2:30, we have Nina Segalowitz, a beautiful Indigenous artist who's going to speak to us about the transmission of Indigenous art as to help recover from trauma. And she's going to share with us a performance, throat singing. So I've heard her before. She's absolutely extraordinary. So if you can stay, I don't think you'll regret it. And for those of you at home who can stay with us, thank you so much to everyone who's here today. And thank you so much, Professor Natasha Bakht.